Atul, thank you very much for accepting our invite.
No, it's my pleasure, sir. It's
Yeah,
my
it's
pleasure always.
going to be our pleasure to hear you speak. Okay, yeah.
We are live now, ma'am.
Thank you so much, Keshivji. Okay. So a very warm good morning to all of you. On behalf of Center for Environmental Law and Climate Change at Jindal Global Law School, I, Stuti Lal, would like to welcome you to Deconstructing Environmental Justice webinar series, lecture number 4, with Professor Dr. Atul Alexander. The theme of this lecture is Environment and International Law, Voices from the International Court of Justice. Before we begin with our lecture series, I'd like to wish everybody a very happy Earth Day. Each year on 22nd of April, we celebrate Earth Day to demonstrate support for environmental protection. And I guess everybody is aware that the theme for this year's Earth Day is Invest in our Planet. So, whatever little step you can take, please do so because Earth needs us and we need the Earth. And with that, I'd like to introduce our panelist for today's lecture, Professor Dr. Atul Alexander. Dr. Atul Alexander is an assistant professor of law at the WB National University of Juridical Sciences, Kolkata, and faculty advisor of the International Law Student Association, WBNUJS chapter. He is an alumnus of Loyola College, the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University, Chennai, and the Korean Maritime Institute. Mr. Atul was also the recipient of the Junior Research Fellow and a university topper in LLB 2014 and LLM 2016. Recently, he completed a diploma course in Law of the Seas with magna cum laude from the Korean Maritime Institute with full scholarship. We'd like to welcome Dr. Atul Alexander. And sir, we are happy and we are thankful that you agreed to be our panelist for this day.
Thank you, Stuti. Thank you for the warm and the kind invitation. And firstly, I would like to thank Professor Tony George for extending this invitation to me. Further, I would like to thank the Center for Environmental Law and Climate Change for hosting several talks on some of the acute areas of environmental law. I would also like to thank the university itself, who the university itself has reached a tremendous height under the vibrant leadership of your VC Rajkumar sir. So with this, I would like to introduce this topic which I would be discussing, which is on environment and international law, voices from International Court of Justice. I have prepared a brief PPT. The purpose of PPT is to not essentially to bore you, just to give pointers to whatever I'm going to discuss. And whatever I'm going to discuss is out of my research that I've done for the past couple of years, teaching public international law for the LLB students. So here, essentially, I'll be sharing my experience on this particular topic. So if I'm allowed to share the screen, please.
Yeah, sure, sir. You can go ahead.
Yeah. I hope the screen is visible.
Yeah, it is.
Yeah. So if at any point you have any doubts, you can stop me and get it clarified. I'll happy to take your doubts. And the template of my lecture would be I'll be speaking for a span of 30 to 40 minutes. followed by the questions. I'll be happy to take more questions, clarify your doubts, rather than giving a monotonous speech, right? So as I said, I'll be discussing on this particular topic, that is environment and international law, voices from the International Court of Justice. So the template of my lecture would be as follows. So firstly, I would be introducing the topic. Second, I would be discussing the ways in which the ICJ can contribute to environmental jurisprudence. Thirdly, the phases in the International Court of Justice where a World Court, or rather ICJ, had to encounter the cases involving environment. And finally, I would be briefly touching upon some of the contemporary challenges and followed by conclusion. To start off with, we are essentially talking about something called International Court of Justice. This is also called as ICJ. This is also called as World Court, which was established in the aftermath of World War II. Essentially, ICJ settles disputes between states, unlike other bodies like the regional human rights courts, which looks into the matters of individual complaints, right? So ICJ was established in post-World War II era, which essentially disputes or settles disputes between states. Essentially, the jurisdiction of ICJ is twofold. Firstly, it decides cases based on special agreement. So if two countries have special agreement, voluntarily submitting to the jurisdiction of the court based on consent, the ICJ will have jurisdiction. Second, it is also has jurisdiction when it comes to optional declaration, where voluntarily states can submit to the jurisdiction of the World Court based on a declaration. And in the declaration, states are free to make any kind of reservations. So these are the jurisdictions that you find with regard to ICJ, and ICJ can also entertain cases involving advisory opinions. Essentially, advisory opinions have to be sought by the organs of the United Nations vis-a-vis the specialized agencies, provided the request for an advisory opinion should fall under the competence of the organs which are requesting for an advisory opinion. Now, interestingly, as I point out in this slide, unlike areas like diplomatic protection, territorial disputes, ICJ's encounter with environmental jurisprudence has been very poor, and I would say it is evolving. So this is something that I would be demonstrating through my lecture today. And this is because when it comes to environmental jurisprudence, states take recourse to multilateral environmental agreements, which are more of regulatory in nature. So states prefer negotiations over settling disputes through a judicial forum like International Court of Justice. That is one reason wherein there is a dearth of cases before the International Court of Justice. Second, when it comes to cases before the International Court of Justice, one of the huge challenges is about standing. So in most of the cases which I would be discussing, the nuclear test case, etc., you will find that the World Court would be devoid of jurisdiction. So it cannot go ahead and decide the case on merits, right? But having said this, the World Court has given few very interesting observations when it comes to environmental jurisprudence, and it has contributed to the larger framework of environmental consciousness, which I would be discussing in the subsequent slide. Now, here I've demonstrated the ways in which ICJ can contribute to environmental jurisprudence. Now, the first way through which it can do so is through an advisory opinion. And as you all are aware, there is a recent advisory opinion pending before the World Court pertaining to climate change, right? So the World Court can give advisory opinions, and it can contribute to advisory opinions and in terms of identifying the general principles of environmental law. For instance, there are cases where the World Court has identified the principles of due diligence. That is the duty to entail or duty to notify and consult. Secondly, it can also act as a tool or a catalyst for strengthening capacity. When I say this, in a lot of cases before the International Court of Justice, like for instance, the recent case of Costa Rica versus Nicaragua, the World Court has identified or given a fresh perspective to customary international law. So ICJ can play a role in terms of identifying CIL or customary international law, identifying principles like environmental impact assessment, identifying other substantive principles like precautionary, sustainable development, etc. So in that manner, the ICJ can strengthen the capacity to the overall framework of environment. Thirdly, it can also play a very significant role in other disciplines of international law. Now, I still remember reading a case, the 1996 advisory opinion, the legality to the threat or use of nuclear weapons, wherein the ICJ brought a very close link between environment and armed conflict in terms of ecological necessity. It can do that. So, in terms of the effect of environment in other branches of international law, ICJ has contributed significantly. Fourthly, with regard to valuation of environmental law, this is quite significant because after 70 years, in the year 2019, the World Court gave a very interesting, decided on a very interesting case involving Costa Rica and Nicaragua, involving compensation for environmental breaches. So after 70 years, for the first time, the World Court is deciding a case on environmental compensation, right? So subsequently, what can happen? This case can become a kind of a trendsetter for the subsequent cases involving environmental compensation, right? And finally, the World Court could also interpret international agreements. Now, I say this because when I read this famous case of Australia versus Japan, which is also called as the whaling case, the World Court had an opportunity to interpret the whaling convention. So essentially what it is doing is it is interpreting multilateral environmental agreement to ensure that when states negotiate, it acts as a useful indicator. So what I'm trying to highlight is when it comes to environment, although negotiation is something that the states would prefer, ICJ can supplement this negotiation process through highlighting or articulating multiple principles or formulating certain key important concepts, right? Now, coming to the first phase. Now, when we talk about the first phase of International Court of Justice, there are two important cases which all of you would have come across. Firstly, the curfew channel case, and secondly, the Barcelona traction case. Curfew channel case was one of the first cases decided by the International Court of Justice. In this particular case, as you know, I'm not going into the facts of this particular case, but what was highlighted in this case was this: a state shall not cause transboundary harm. But one needs to remember that this was not a case particular or pertinent to environment, because it did not address anything related to environment. It is all about sovereignty, the question of sovereignty. The World Court decided in this context, one state shall not harm the other state in terms of transboundary harm. Now, what has happened because of this? This case significantly influenced the drafting of Principle 21 and Principle 2 of the Stockholm and the Rio declarations, respectively, which had a direct implication on environment. So the curfew channel case, which was initially decided by the World Court, although did not have any semblance to environment, had a drastic impact when the Stockholm and the Rio declarations were drafted. So you could see here how the initial cases in the ICJ, or the initial case in the ICJ, acted or provided a tool for the subsequent growth of environmental jurisprudence through the Stockholm and the Rio declaration. Then it also, there is a very important case called the Barcelona traction case. This particular case was important in the context of ICJ because this case propounded this theory of erga omnes obligations. Erga omnes obligations are obligations which a state owes to the international community as a whole, and every state has an obligation to respect the erga omnes obligations. So the World Court in the Barcelona traction case identified 4 such obligations which constitutes erga omnes obligation. Mind you, this case did not also have any aspect of environment. But what I'm trying to highlight is the notion of environmental, or what we call as erga omnes obligation, can also be extended to environmental jurisprudence. And this was quite evident when the draft articles on state responsibility was drafted by the ILC under the stewardship of James Crawford under Article 48. In the commentary, if someone reads, he or she would appreciate the fact that environment is also mentioned as one of the yardsticks for invoking erga omnes obligation. Although this has not been invoked till date in the docket of the World Court, if a state wants to invoke erga omnes obligations, environment could also be considered or taken into account while invoking erga omnes. So the initial phase in the ICJ witnessed two important cases, as I've pointed out, the curfew channel and the Barcelona traction case. Although both the cases did not address the issue of environment or climate change, these two cases indirectly contributed to the growth of environmental jurisprudence through the subsequent drafting of the Rio and the Stockholm Declaration. Now, after this case, there was a very important case that came up before the World Court in the early 1970s. This case is also called as a nuclear test 1 case involving Australia and France. To brief you on the facts, France had carried out atmospheric nuclear testing in the Pacific Ocean. Australia said this was in violation. This was a gross violation and it also affects the environment, right? The problem, what happened subsequently, that France gave an undertaking, or what we call as in international terms, unilateral declarations, that it will no longer carry out nuclear testing. So what happened? This particular case did not go into the merits because the dispute was ceased, because there was no longer a dispute, because France had given an undertaking that it will not no longer carry out nuclear testing. So there was this absence of dispute. Subsequently, the case did not go into the merits. So some scholars point out this was a missed opportunity wherein the World Court could have clarified the use of nuclear weapons and its impact on environment. But interestingly, the Spanish judge in this particular case, you all should read this. It's a very interesting opinion by Judge D. Castro. He's a Spanish judge. He gave a very interesting opinion in stating that and I quote, radioactive fallout on the territory of other state was illegal. Now, this is something somewhat related to what was stated in the curfew channel case, but in a different context. Now, this particular opinion would have been reflected in the subsequent advisory opinion, which I would be coming into. Now, after this, what happened after the initial phase of this caution, there was this period of what we call as consolidation phase, where the World Court had to decide cases on environment in the backdrop of multiple multilateral environmental agreements. Now, you all would agree that in the 1990s, there was this rise of environmental consciousness, wherein there was this Kyoto, this Rio, etc., came about, and people started speaking environment, and environment became the talk of the town. Now, whether this impacted the working of the World Court vis-a-vis environment, this was tested ideally in this particular case called as a Nauru case. Nauru case is a very, very important case. Of course, it's not totally related to environment, but in terms of environment, it also had an opportunity. The World Court had an opportunity to clarify a lot of contents. So what happened in this case? Nauru, a small island, took Australia to the World Court, saying that because essentially Australia was the trusteeship authority. So I'm not going into who is a trusteeship authority, but Australia was a trusteeship authority, and it has certain obligation towards Nauru. As a trusteeship authority, Australia had carried out illegal mining of phosphate, and this resulted in environmental degradation. Now, Nauru wanted a kind of compensation from Australia for the illegal mining that was carried out by Australia. But even in this case, what has happened, both the parties decided to settle the case out of the court. So they decided that we'll no longer seek the assistance of court, and the issue was settled outside the court, and there was no dispute. Subsequently, the World Court did not get the opportunity to decide on this particular question. So you could see in the nuclear test 1 case and the Nauru 1 case, the World Court was asked questions on environment, but because of certain jurisdictional hurdles, it could not go ahead and decide on these two important cases. Now, subsequently, what happened? There came a very important case, that is nuclear test 2 case. This involved France and New Zealand. So this case was an offshoot of nuclear test 1 case, because New Zealand wanted an interpretation of one of the paragraphs, that is paragraph 63 of the nuclear 1 nuclear test one case. Even in this case, what happened? Although New Zealand had invoked multiple environmental law treaties, like as I mentioned, the 1986 Convention on the Protection of Natural Resources and Environment of the South Pacific, and other principles of environmental law, the World Court said it did not have jurisdiction because the request that was sought by New Zealand fell outside the scope of paragraph 63, which was the judgment that was given in the year 1974 in the nuclear one test case. Now, but what happened in this case, interestingly, there were three judges. You would all be aware of Judge Christopher Gregory Veeramandri, Judge Koroma from Sierra Leone, and ad hoc Judge Jeffrey Palmer. So these three judges gave very interesting observation. Jeffrey Palmer went to an extent in stating that EIA, that is Environmental Impact Assessment, and precautionary principles have attained the status of customary international law. This is quite important because this was not something that was addressed in the previous cases before the ICJ, but for the first time, through a separate opinion, the World Court had articulated that EIA and precautionary principles have attained the status of customary international law. But the issue in hand was the World Court did not give the substance to how EIA should be carried out, when EIA should be carried out, etc. was not explained in this case. And this is something that came to haunt ICJ in the subsequent case of Gyapchikovo and the pulp mills, which again I'll be discussing in the upcoming slide. Then came a very, very interesting case. This case, I think I have missed a slide here. Yeah. Yeah, so this case was the Gyapchikovo-Nagimuros case. It's a very important Gyapchikovo-Nagimuros dam case. In this case, before that, there was another case which, I mentioned this in that slide, that the nuclear weapons case, this was an advisory opinion that was sought by the General Assembly to the International Court of Justice. So what was an advisory opinion asked, or the question that was asked was this: whether the use of nuclear weapons is prohibited or not. This was the advisory opinion that was sought to the World Court. The World Court should have answered yes or no, right? But the World Court, being a World Court, said we are not able to give a clear answer as to whether the use of nuclear weapons are prohibited or not. Right. So it reached a stalemate. The decision could not have been arrived, and so there was this. There's a very important legal term that is non-liquid. Non-liquid essentially means that the World Court could not arrive at a solution when this question was asked. But interestingly, World Court made a very interesting observation in one of the paragraphs, linking both environment and nuclear weapons. And I quote, what was said was this: state must take the environment into consideration when assessing what is necessary and proportionate in the pursuit of legitimate military objectives. So that essentially means the World Court is essentially connecting environment to armed conflict, right? So when a state carries out an armed attack with a purposeful, legitimate objective, it has to consider environment when it is considering the question of necessity and proportionality. And necessity and proportionality are some of the core principles of humanitarian law. So World Court here went an extra mile in saying that there is a logical connect between environment and armed conflict. And this takes me to the first slide, wherein I discussed that how ICJ's environmental contribution has influenced other disciplines of international law. And this is a classic example of that. In addition to this, Judge Christopher Gregory Veeramandri, you would have all read his celebrated opinion in this particular case, clarified the extent and scope of what is sustainable development and how it fits into the larger scheme of right to development. So if you want to know more about the discourse or the debate between right to development and sustainable development, you should definitely read his opinion. But in addition to that, he also highlighted the importance of intergenerational equity, other cardinal principles of international environmental law. Now coming to the next case, this case was decided 1 year after the advisory opinion. That is the Gapchiko Nagimoros dams case. This case was very simple. Both Hungary and Czechoslovakia and subsequently Slovakia entered into an agreement for the construction of dam. And Hungary, subsequently because of the change in government, they wanted to suspend the construction of dam and subsequently terminate it. Now the question is whether Hungary could do that. This was a larger question. And one of the arguments that was placed by Hungary was because of environmental reasons, if you go ahead with construction of dam, it will have a detrimental impact on the environment. So essentially the argument was Hungary invoked the argument of necessity. So we are not going ahead with the construction of dam because it would affect the principle of necessity, and necessity is one of the circumstances precluding wrongfulness under the draft articles on state responsibility. So the question was whether environment could be taken as one of the factors in gauging necessity under RCEVA. In other terms, whether ecological security can be taken as a factor in determining the notion of necessity under RCEVA, precluding wrongfulness. The World Court said, no, environment is something that is very uncertain and it is something that is subject to future development. So we will go for stability of treaties instead of interpreting environment as one of the relevant factors. Here again, the World Court, this case, the World Court had a unique opportunity. Unlike other cases, because unlike other cases, there was this strict jurisdictional hurdle. The World Court could not do anything because of the structural limitations. But in this case, this was a contentious case. The World Court went to the merits. The World Court could have traveled an extra mile and could have said that necessity would include environmental harm. It could have done that and it could have contributed. But again, it had failed to do that. But again, Judge Veeramandri came to the rescue, and he was of the opinion that environment rights were also considered as human rights. And if you read a lot of judgment in the European Code of Human Rights, even today, there has been a lot of debates as to whether environmental harm would constitute human rights, right? And I still remember a case involving Netherlands, Urginda. It's a very important case where the courts of Netherlands fixed responsibility on Netherlands to cut down on the pollution level. So what I'm trying to highlight is here the World Court had a unique opportunity to clarify or to expand the scope of environmental jurisprudence, but it failed to do so. Then came a very, very interesting case. This was a hardcore case on environmental law, which is the pulp mills case involving Argentina and Uruguay. And this was a case that came up before the World Court in 2006. And the World Court had to decide whether the construction of these two pulp mills by Uruguay was in breach of the 1975 River Uruguay Statute. So essentially whether the construction of pulp mills was in violation or breach of agreement that was signed between Argentina and Uruguay. And the contention that was placed by Uruguay was Argentina was this would violate environment in terms of causing pollution to the river, if I'm right, River Danube. And also Argentina argued that Uruguay was in violation of procedural environmental law obligations. This includes environmental impact assessment, obligation to carry out an environmental activity by exercising due diligence, and the obligation to notify and negotiate. So this was the argument placed by Argentina when Uruguay had violated the 1975 treaty. The World Court had an opportunity here to discuss the content of environmental impact assessment. Now, when I judge a moot court like Stetson, this is the case that the teams mostly refer. In all the Stetson moots I have judged, this is a very important case that teams essentially rely on. That is the pulp mills case. So the World Court here had an opportunity to clarify the content of procedural environmental obligation like EIA, due diligence, obligation to notify and consult, etc. Now, what had happened in this case, although the World Court had an opportunity to do that, it miserably failed, because although it said environmental impact assessment should be carried out when there is a significant harm and environmental impact assessment should be done on a continuous basis, it did not clarify whose obligation was it to carry out EIA, whether EIA should be carried out under a particular international framework or whether it fully falls under the mandate of the domestic states for a transboundary harm that might occur subsequently, right? So then came a very interesting case, which of course I'll be discussing these two cases: certain activities carried out by Nicaragua in border area and the construction of road in Costa Rica along the river San Juan, 2015 judgment, and subsequently there was another judgment in the same case that was pertaining to compensation. And mostly these two cases, aerial herbicide spraying case, Ecuador and Colombia, another case that came up before the World Court. Again, in this case, what happened? The World Court could not decide on the merits because both the states decided to settle this dispute out of the court. So the World Court again had missed an opportunity to decide this particular case. Now, coming to some of the challenges and conclusions. Now, in the pulp mills case, I'll start with this particular case. What was not said? Due diligence obligation entails the adoption of appropriate rules and measures. This was the definition of due diligence that was given in the pulp mills case. Now, the World Court unfortunately did not articulate the exact standard of due diligence. It only randomly said that states have to carry out or adopt appropriate rules and measures. What are these appropriate rules and measures? The World Court failed to clarify, and in turn raises a very important question whether these adoption of appropriate rules are obligation of conduct or obligation of result. Now, what is the difference between obligation of result and obligation of conduct? Obligation of conduct essentially means states have to carry out certain measures to the best of its ability. That is obligation of conduct. Obligation of result essentially means that states have to carry out certain appropriate rules or measures so that a desired outcome or result is reached. So the World Court did not clarify whether it's an obligation of conduct and or obligation of result. Now, interestingly, in the 2015 advisory opinion of ITLOS, the ITLOS gave a very interesting observation on this, wherein it said that due diligence is essentially an obligation of conduct. But the World Court in this particular case failed to do that, right? Now, secondly, for carrying out environmental impact assessment, there is a requirement of significant harm, right? Right. Now, what is a significant harm is something the World Court did not clarify in the pulp mills case. And the World Court also did not clarify whether EIA is a customary international law. And if you read the opinion of Dalbir Bhandari in the Costa Rica versus Nicaragua case, he would have highlighted this shortcoming of the World Court. The World Court would not have stated in clear terms what is opinio juris, what is state practice in identifying the CIL nature of EIA. Right. Although the World Court would have said EIA is a CIL, but World Court did not clarify where is the state practice and opinio juris. And if you read public international law, you will be aware that for identifying CIL, you require state practice and opinio juris, right? The famous North Sea continental shelf case of 1967. But World Court did not identify any state practice or opinio juris. So there was this lack of procedural precision when it came to this particular case, and subsequently in the Costa Rica. So you need to read pulp mills and Costa Rica in the same, keep it in the same pedestal and read it accordingly, right? Thirdly, the World Court said precautionary principle is an approach and not a principle. So essentially, the World Court randomly said there is a principle called as precautionary principle. There's something called a sustainable development, but it did not inject any juice or any content into these principles. So that makes the matter more complicated. This is because other tribunals have clarified the exact scope and content of what constitutes precautionary principle, but ICJ has failed to do that. Again, it was a missed opportunity for the World Court, right? And in the subsequent case of Costa Rica versus Nicaragua, this is something that I thought of discussing today. It's something on valuation of environmental damages. This is quite interesting because it was only in the year 2019 for the first time the World Court had to decide on environmental harm vis-a-vis reparations, in spite of World Court having to decide on multiple cases on environmental aspect. So what exactly happened in this case? There was a question of transboundary harm. The Costa Rica argued that Nicaragua was in violation of certain obligations, and it requested substantive obligation. You can only request for reparations for substantive obligations, in the sense compensation. So the argument of Costa Rica was Nicaragua was in violation of certain transboundary principles, so hence it wants compensation. And it took nearly 4 years for the World Court to decide from the date of the judgment on merits. So this case was decided in 2019. And if you want to read more on this, you can also refer to, there's a beautiful writing by Professor Diana Deseredo. This is available in EJL Talk, where she gives a detailed exposition of what this uh, approach taken by the World Court was with regard to compensation. And she essentially critiques the judgment in the Costa Rica versus Nicaragua. So the request of Costa Rica was 6.7 million US dollars for the environmental harm that was caused by Nicaragua by constructing a road in the border region. Now the World Court ended up giving only 5% of the requested claim by Costa Rica by relying on a very, very weird case. I would say weird case because this case was nowhere related to environmental law. The World Court relied on the Diallo case. Diallo case apparently was decided by the World Court in 2007. That is the case involving Ahmed Sadio Diallo, where he was an individual. His property was appropriated by the government, and he was represented by his state, and he sought compensation from the World Court. And the World Court applied the principle of, it gave compensation based on moral consideration to this individual, Ahmed Sadio Diallo. So the World Court, while deciding on environmental case, referred to the Diallo jurisprudence and gave compensation, which was around only 5% of 6.5 million US dollars that was sought by Costa Rica based on the ecosystem approach. What is ecosystem approach? That essentially means that when there's environmental harm, the harm is not only caused to the injured state, but the harm is also to the environment. So the compensation essentially has to be exemplary, right? That was the argument taken by Costa Rica. And argument taken by Nicaragua was, we are ready to pay compensation, but we'll go by another method called the replacement cost method. That essentially means that we are only paying for the violations that have been incurred to the injured state. And the World Court said, we are not going for any of these two methods, but we'll go for another method. That is what we call as the method that was devised in the Diallo case. That is the overall assessment method, and gave only 5% of the compensation, right? That is quite weird for kind of environmental violations that were committed. Now, there's another very important challenge, which I think one of my colleague also has addressed in one of her articles, which apparently I read, Chaya Bharadwaj. This is with regard to the science intense environmental dispute. That essentially means that when faced with questions of environment, which also involves question of science, the World Court has tended to decide unilaterally rather than relying on expert evidence or expert witness. The World Court has not relied on experts while deciding a case involving environment, because environment would involve question of science. So essentially, the World Court, being court of law, cannot decide on a question of science merely by applying scientific facts. It doesn't have the prerequisite, I would not say knowledge, I would say expertise. So the World Court under Article 50, that is Article 50 of the ICJ statute, talks about experts. Unfortunately, the World Court has not consulted experts in multiple cases while deciding a case. Now, this is quite ironical because in the curfew channel case, which was one of the first cases decided by the World Court, although this was not related to environment, consulted 3-member expert bodies. But subsequently, you will find in the case of pulp mills, Costa Rica, Nicaragua, etc., the World Court did not take the assistance of experts, although this option is available under the ICJ statute. So this is something that the World Court could consider invoking while deciding cases involving environment. Now, as I point out here, in Gapchico Nagimaro's case, the World Court said uncertainty in science means mere future possibility. It did not rely on any expert. And in the pulp mills case, it only appointed experts which were suggested by the parties. It did not appoint experts on its own. And in the interesting case of Australia versus Japan, that is the whaling case, again, to identify what constitutes scientific research, because the core of this particular case was to define what is scientific research. The World Court did not again rely on experts. It only relied on, as I point out here, scientific committee of International Whaling Commission to define what is scientific research. So my another conclusion here would be the World Court could do well if it relies on scientific experts while deciding environmental cases, which are usually riddled with scientific questions, right? Yeah. Now, coming to some of the conclusion which I have identified in my little research that I have done, ICJ lacks engagement with core environmental issue. This is due to structural limitation and lack of will. Hope you understood. That essentially means structural limitation is because ICJ's jurisdiction is based on consent. So without consent, the World Court will not essentially have jurisdiction. So there is a structural limitation there. Secondly, there's a lack of will because the World Court has not clarified certain content, like what is due diligence, whether it's an obligation of result or conduct, what is EIA, how it has attained customary international law. The World Court has not clarified. So as I point out here, ICJ's lack of engagement on environmental issues because of lack of limitation or lack of will or structural limitation. Secondly, advisory opinions can be a way forward in deciding a case on environment because advisory opinions, although not binding, gives considerable flexibility to the World Court because they are not bound by the complexities of states arguing before them and then deciding. So essentially in advisory opinions, the World Court can go an extra mile and decide a case, give a very flexible interpretation on environmental issues. Now, hopefully when there's a request for climate advisory opinion that has been sought by the UNGA, although the entire opinion that was sought is only one page, some of the questions are very, very interesting. It only time would say how the World Court would go ahead and decide, right? And another suggestion that I have is when an advisory opinion is sought, it should be in a very streamlined manner. It should not be in a vague language. So the language of an advisory opinion that is sought to the World Court should also be very refined, right? It should not be giving a kind of wiggle room for the courts to not answer those questions. So the request should also be very precise. Thirdly, environment is still conceived as an ancillary issue to the overall dispute. So whatever cases I've highlighted today, most of these cases, environment was seen as an ancillary issue, as an offshoot of territorial dispute, as an offshoot of something else, like for instance, construction of something, development project, and subsequently case coming up before the World Court, and environment was invoked as one of the arguments. So environment is still seen as an ancillary, or it's seen as a secondary line of argument by states rather than seeing that as a primary line of argument. And finally, ICJ can borrow from other regimes to develop a robust environmental framework. And for instance, in the article that I pointed out, written by one of your faculties, Chaya Bharadwaj, she points out that PCA, Permanent Code of Arbitration, has a very science-based approach to environmental law cases. IT laws could be another example where it could be relied to decide on environmental cases. So these are my few conclusions and observations that you have. You have any questions, I'll be happy to take that. I understand this can be a bit dry, teaching international law, but I hope you all understood. And if you have any questions, please post it in the chat box or you can address to me directly. Yeah, thank you.
Thank you so much for the insightful session, Dr. Alexander. The floor is now open for questions. If there are any, we would love to answer them. Okay, one second.
Yeah. Chaya, you have a doubt. Chaya wants to ask.
Yeah, one second. I think Mr. Prateek can go first.
Oh, hi. Am I audible?
Yes, you are.
Hi, Dr. Alexander. Thank you so much. This was so very interesting and also something that I've been researching on, so it aligns very well with areas that I have dealt with. More specifically, the jurisprudence of the court, starting from Corfu actually and coming up till Costa Rica, Nicaragua. So just I had a couple of questions actually. Firstly, I mean, you've pointed out that there is lack of scientific expertise on the bench. And of course, that has been a problem which has been highlighted many times by the court and also in many times in the dissenting opinions, actually, in Pulp Mills and Gachikovo and Whaling. So that is something that the court knows that it lacks. Do you have any thoughts or inputs about perhaps what can be done to integrate science into law? Because what we're expecting is lawyers to speak the language of science and scientists to speak the language of law, which is a difficult marriage to meet sometimes. And I mean, we do it in NGT in some way because it is integration of experts who sit in the technical capacity and lawyers. So, is there, do you think, a possibility of something like this perhaps in the World Court as well, where science can be integrated? Any
Uh,
thoughts on that?
Yeah, so in the mid 1990s, a different kind of mechanism came into existence wherein an environmental chamber, separate environmental
Yes.
chamber was created
Yeah.
by the World Code to address questions
Such
involved in,
matters.
yeah, such
Yeah.
matters, but it did not take off, right, for some
Yeah, it
reasons.
was a stillborn. It was discontinued in 2006, if I'm not wrong.
Yeah, so one way to assess or to or I would say reform this could be the world code could, as I pointed out in my presentation, there's an option to appoint experts, right? Article
Right.
50 of the statute of the world code gives this opportunity, but I'm not sure because of what reasons the world code has not pressed into service this particular provision.
Yeah.
But in some case, I think if I'm right, in the Gapchigo Nagimoro's case, the judges of the world code went to the place itself to assess
Yeah.
the, if
That's
I'm right,
Gachikovo Nagimaros.
yeah, to assess the ground realities, and in cases beyond territorial, beyond environmental disputes. For instance, I remember the Botswana Namibia case, the
Uh,
Kasisi Suduru Island case.
Sisidilu.
Yeah,
Yeah.
so again, the world code went to the field and investigated. So what I'm trying to highlight is there are options which are available, but the world code has not. Now, again, it would be interesting how uh, the ITLOS, you can even compare this with ITLOS, right?
Right.
International Tribunal for Law of the Seas, how they have approached these questions of science, how they have relied on cartographers, for instance, geographers,
Right.
what mechanisms have they adopted. But it would be a very interesting research question because I'm not done much research on the ITLOS. Maybe ITLOS could have some inputs that would.
Answers to give. Yeah, in fact, even there are some rising domestic cases. For example, I think there is this ongoing litigation in Germany, which is by a Peruvian farmer, Liluya versus RWE. In that case, also, I think the judges have now gone to Peru. German judges have gone to Peru to scientifically assess if the quantum of damage that is being claimed is that something that is proportionate, or is that even something that can be accommodated for this
Can you,
particular request?
can you repeat that case? Maybe I'll do some reading on that. Yeah.
Yeah, I think it is Liluya, Lilyua,
Okay.
versus RWE, I think, which is one of the highest emitting companies from Germany. And the claim is actually very interesting in that case because this Peruvian farmer in Peru is asking for a compensation uh, up to the percentage of emissions that this company has made. This company, RWE, is the sixth highest emitter in the world. And the percentage of carbon emissions that they've contributed to global warming, that much percentage of compensation they're demanding for the melting glaciers in their town in Peru. Um, and German courts have entertained it, and because a civil code allows for such a claim. So that has been one interesting development where science is actually being integrated in some way.
Okay.
Yeah.
Thank you for that.
And I had one more question, if I
Yeah, please,
may.
please go ahead.
Yeah, you were also discussing about the non-linearity in the compensation. Firstly, compensation is rare when it comes to ICJ. There are overall only four cases. Only one of them deals with environmental compensation. But there was also this one very recent judgment last year by the ICJ in the ongoing dispute, DRC versus Uganda.
Yeah.
Uh, Wherein there is compensation awarded for I think somewhere around 60 million or something for to DRC for for plundering and for looting and harm to natural resources. And there, the approach adopted is altogether different, apparently. So, I mean, it is not the overall assessment method, it's some global sum principle.
Yes,
Any
yes.
thoughts on that about is that, right direction? Is that conflate things?
I've not specifically read that case, but I've read few blog posts on this particular case that you are referring to. That case, if I'm right, the compensation came after a period of 13 or 40 years, 14 years, if I'm right. The original case was
Yeah,
decided. Yeah.
25. Yeah, yeah.
So the case itself was decided in 2006 or 7. Correct me if I'm wrong. And the World Court said states have to negotiate to find an amicable solution. If it fails, the
Right,
party can approach the World Court for subsequent compensation. And it took nearly 14, 15 years for the World Court to give compensation.
right,
And
right,
interestingly, if I'm right, it relied on one of the arbitration proceedings when while granting compensation. I'm not able to exactly recollect that particular case. Uh, so Guinea-Bissau, if I'm
Eritrea,
yeah,
Eritrea,
Eritrea Claims Compensation Commission, right? If I'm right.
right. Yeah,
Yeah,
yeah. Eritrea damages claim. Yeah, yeah, yeah. That one.
yeah. I've read it in the context of humanitarian law and human rights law, but again, if I'm not, if I guess it's also there's an issue also on environmental law, as you point out, right? So
Yeah,
I'll go through it then. Yeah.
yeah, because over there also, the court said that in exceptional circumstances, we may award compensation on this principle called global sum,
Hmm.
wherein there is no evidence, or we know that internationally wrongful act has happened, but there is no precise evaluation or evidence or to the scale of the injury. Therefore, we sum it up to a certain number, which
Hmm.
they think is appropriate, which is not science backed, um, and given.
Yeah,
So I think that
but the compensation that was rendered, if I'm right, was not what was requested. So it was not even half of what was requested,
it
right?
was, yeah, I think 3-4% of apparently what was requested, some very small number.
Okay.
Yeah. All right. Okay. Okay. Thank you so much, Doctor.
Thank
That was
you.
very
Thank you.
helpful.
Thank you.
Thank you so much, Professor Prateek. We have Professor Chaya's question next. One second. Just yeah. So, Professor Chaya's question is, uh, in climate change advisory opinion, there are going to be several questions of science to establish historical or current responsibility. IPCC is likely to play some role, but it does not point specifically which country emit or emitted what. Now, there is also alternative science developing saying there is no climate change. How do you think the ICJ can do in these circumstances?
Firstly, I would like to make it very clear. It's like a caveat that I would like to say that uh, I mostly discussed on matters pertaining to environment, not insulating or isolating climate change. But for the purpose, because what she has asked, I can maybe give some inputs on this in the overall scheme of advisory opinions. Now, requesting an advisory opinion on climate change, I have this. This is essentially my view. It is not going to be a panacea. So it's not going to result in much of a difference. It can even backfire. So there was a very interesting read that I did in Agile Talk on be careful with what you ask. So I can give you an example of this. So in the initial years of the ICJ, the request for advisory opinion was based on question of the functioning of United Nations. In the mid 80s and the 90s, it was mostly on questions of sovereignty between disputes between states. Classic example is Palestine Wall opinion. In the third phase of advisory opinion, you will see all these abstract questions that were asked to the World Court in the form of an advisory opinion. Now, what can happen when it comes to all these abstract questions that are asked before the World Court? The World Court could also give an abstract answer. Now, for instance, in the Chagos case, the advisory opinions in the Chagos archipelago, the World Court said the United Nations General Assembly has to show the way as to how this matter has to be settled. So essentially, what it did, it passed the buck to the United Nations General Assembly. The question was, if I'm right, I'm not sure it was SC or GA, but the answer was very abstract. In fact, in certain cases, it could also backfire. For instance, in the legality to the threat or use of nuclear weapons, the World Court said we are not able to give an answer. So some states might say not giving an answer means affirmative. So we can use nuclear weapons in the form of self-defense. So merely asking an advisory opinion on climate change, the World Court would give some inputs, but it can also be in a very abstract manner. One, it can also in fact backfire. But thirdly, what it could also do is it could also clarify certain important abstract concepts, like what the World Code has done previously, right? It can do that. But I've read the request that was asked. It's a one-page report. I mean, the request, if I'm right, one is with regard to the responsibility of states, and second is with regard to the legal consequences of, if I'm right, climate change. You can correct me if I'm wrong on this. And there might be issues, as you rightly pointed out, on questions of science. Now, it's quite fascinating and interesting. I've not seen any case, especially with regard to advisory opinion, where the World Code is grappling with the question of science. Again, this makes for a very interesting moot question. How would, in advisory opinion cases, will the World Code decide on questions of science and vis-a-vis environment? And this is what I could say. But having said this, one of the other reasons, maybe if there's any other inputs on this, maybe I'll be happy to take that.
Okay, thank you so much for answering that question. Next, we have Professor Tony George. Professor George, I'd like to request you to unmute and ask your question.
Oh, thank you, Stuti. Thank you very much. Atul, very good presentation, a nice presentation, very concisely put. Now, I have some questions for you. The first question is with regard to the will. You talked about the will aspect. So what happens is that usually we find that several cases come up before the International Court of Justice. For example, we had the Mox plant case, and then we had Singapore versus Malaysia. And there's a lot of hue and cry. I mean, a lot of people get interested. There's a sudden interest in the ICJ. And then what happens ultimately is that the whole thing fizzles out. It just dies without even a whimper. So that's what we find. And then we find that in most of the cases, for example, the status of the precautionary principle, whether it is part of customary international law or not, we find that there can be a separate opinion or there can be dissenting opinions. But never does the court actually take the bull by the horns. So you always find there's a general reluctance on the part of the International Court of Justice to decide matters relating to the environment head on. So what do you feel? What could be the possible reason behind this reluctance on the part of the International Court of Justice, on the part of the World Court, to actually deal with such kind of matters? Is it political or is it something else? So I would like to hear your opinion on that part. Yes.
Now, in case of advisory opinion, thank you, sir, for that question. Firstly, yeah, in cases of advisory opinion, the answer could be political, because according to Article 65 of the ICJ statute, the World Court cannot decide on a political question. When an advisory opinion is sought, it can only ask a question which is legal. So that is where, when an advisory opinion is sought by any of the organs of the United Nations, it is formulated in such a way that, for instance, the legal consequences, the legality. So this is the language of advisory opinions which are sought, because the World Court can only decide on legal aspect. Climate change, for instance, can be very political, because a lot of states are involved in the entire discourse of climate change. So it can be very, very politically volatile. So the World Court will not dwell into such questions of politics. That could be one reason when it comes to advisory opinions. Now, with regard to contentious cases, I would say the foremost reason would be the structural limitations. Now, for instance, I don't see any environmental treaties having a dispute settlement clause submitting to the jurisdiction of the World Court. Unlike treaties like, for instance, on diplomatic protection. When I say diplomatic protection, for instance, the Vienna Convention on Consular Relations has a dispute settlement clause under optional protocol 1 submitting to the jurisdiction of the World Court. But I'm not sure whether any multilateral environmental agreements will have a dispute settlement clause submitting to the jurisdiction of the World Court. So essentially what happens, the primary means of settling dispute is through negotiation. And I argue that ICJ could essentially supplement this particular exercise of negotiation. It cannot go beyond that, because we are also talking about question of state sovereignty. The other hurdle that I conceive here is you have something called the ICJ's jurisdiction is primarily based on consent. So unless states give consent to a multilateral treaty, it is rare, not rare, it is impossible to drag a state before the International Court of Justice. Even in the optional declarations which are submitted by states under Article 36, paragraph 2, I don't think environment is something that would be put as one of the primary dispute that the ICJ can take up or entertain. So even as I point out, the UNEP, other regional environmental law treaties, environmental law documents, declarations, etc., are not very legal. So if someone reads the Rio Declaration, Stockholm, and the umpteen number of subsequent agreements and declarations, these are very lightly legal, not very legal, right? Unlike other treaties in other disciplines of international law. So that could be another reason. Now, of late, there has been a lot of cases before the ICJ on human rights. And this is because states are invoking conventions like the Convention on the Racial Discrimination, Elimination of Racial Discrimination, which has a provision, a dispute settlement provision, wherein the parties can take the other side to the World Court. So one way to reform this could be environmental treaties could have a provision wherein there is a reference to ICJ when there's a dispute or when it comes to interpretation of questions of international law. But again, this is easily said than done, right?
Thank you, Atul.
Thank you.
Thank you so much, Professor George and Professor Alexander. One second. We have another question from Professor Chaya. In a moment, I'll be able to unmute her. Professor Pratik, do you have something to add?
Hi, yes, very quick point. It was very interesting when Professor Atul just mentioned about there are very few environmental treaties that actually provide dispute settlement mechanism as an approach to the ICJ. And there are very few. This is an interesting area that needs to be explored. Interestingly, the most recent treaty that is being debated, that is the BBNJ, Protection of Biodiversity Beyond National Jurisdiction. The draft of it has a clause which says that in case of any dispute on the application or interpretation of this agreement, can be submitted to any of the courts like ITLOS, ICJ, and Annex 7 and 8 special tribunals. So I think that was one interesting development, that a new treaty is referring to the ICJ for settlement of disputes, and I thought I should just add that.
Thank you so much.
That's about it from my side. Thank you.
Thank you so much for your valuable input. Next, we have Professor Chaya. Professor Chaya, I'm requesting you to kindly unmute yourself.
Hi, Stuti. Am I audible?
Yeah, you're audible.
Yes, you are.
Okay. All right. Thank you. Hi, Professor Atul. How are you? Thank you for this fantastic presentation. And I really liked it when you mentioned that advisory opinions can actually backfire, and we've already seen it in the nuclear advisory opinions case. In continuation to what I had asked you, the advisory opinion that is requested to the World Court right now for climate change is interesting because it is talking about legal consequences, and of course, legal consequences would be historical, current, and future as well, because the question talks about intergenerational equity. And so there's this, interesting linkage between human rights and the World Court as well. Now, when you said in your response that it could backfire with the abstract of questions that have been asked to the court previously, and especially in this climate change opinion, I think you're right, and my fear is that this might lead to no responsibility for any state, and primarily because of the climate change science deniers that are existing. And then there's this also conflict issue, which can say, okay, so climate change is happening because of greenhouse gas emissions, but the greenhouse gas emissions are happening for development, and so all the states and all the peoples have a right to development, and so it is conflicting here. But then the same argument can also be raised by the developed countries, which can say, even historically we did this for development and should be considered as a right to development. And so there's this another conflict here, that is coming to surface as we are talking about it more. So I just wanted your views on that as well. And I think it's definitely going to backfire.
Yeah, Chaya, thank you for that. Picking from what you asked, especially in the context of human rights, that's a very important term that you mentioned in the discourse of climate change. There was a very interesting case in the European Code of Human Rights. I'm not able to recollect this case. The case was all about uh, whether right to environment would include right to life, and whether this right can be claimed as a human rights before the European Code of Human Rights. So the World Court said the applicant has to prove the causal link. So establish the causal link that that essentially he or she has to prove the causal link between the alleged omission of a particular state. In this case, it was Switzerland, and the effect on global warming. So essentially, when it comes to even human rights vis-a-vis climate change, interestingly, the regional courts, including the Human Rights Committee, has taken a very strict, given a very strict interpretation. Now, most of you would be aware of this famous decision given by the Human Rights Committee, involving a refugee seeking asylum in New Zealand, right? And one of the arguments taken by him was on human rights, but that was denied by the World Court because the threshold for human rights in the context of climate change is abstract and it is very high, right? And what was the other question that you had asked, Chaya?
So my second question, I'll get to the second question again, but just to continue with the human rights conversation over here. So in both the human rights decisions before the Human Rights Committee, the Toshiyota case and the Daniel Billy case, both were climate change and right to life, right? And so in both these cases, the Human Rights Committee said, we'll establish that the state is violating human rights of the people as long as there's a causal link. But the causal link should have two standards: that there should be imminent threat to life, that's number one, and number two, there should be foreseeable danger.
Yes.
And they said both the conditions were not met. And this is a very interesting take by the Human Rights Committee, because climate change and sea level rise is foreseeable scientifically, but definitely does not constitute an imminent threat to life. And so, for example, in both the cases, it was sea level rise, and sea level rise is a slow onset disaster. And so maybe it'll, damage human rights in next 10 to 15 years, but not immediately. And so that is the standard that is going on right now. And so ICJ's take on it will be definitely interesting.
So to add to you, this is the only option that is available to climate refugees, by the way, because Refugee Convention also doesn't house climate refugees, right? So the only way for climate refugees to approach these courts would be through the human rights route. And interestingly, the German courts have been very proactive in this. Recently, I remember a Bangladeshi citizen was given asylum status because his health was at risk because of the increasing levels of pollution in Bangladesh. So this is again another option that is also available to refugees, interestingly, the human rights route in the context of climate change, right?
I agree. My second question was in relation to development and greenhouse gas emission conflict. And so the idea is that we need fossil fuel based development, which will emit to ensure a right to development, especially to the developing countries and the LDCs. And so therefore, for current responsibility, the one of the defense that developing countries have been taking, at least at the negotiations, is that we need to develop and and for that there are going to be greenhouse gas emissions, and just from, and because it's not wrong, but then there's this conflict between, you know, right to development and protection of environment, and so this sort of defense can also be taken by the developed countries for their historical emissions, wherein they can say we also needed to develop, and therefore we haven't really engaged in an illegal internationally wrongful act, but it's just sort of that conflict between development and fossil fuel based development. And so what do you think could be a more rational or reasonable approach in such sort of defense?
I think I should be very frank here, because this is an area that I've not explored much. So I think it would be prudent on my part to not comment on this particular question that you asked. But anyhow, maybe since you have raised this issue, I can maybe do a background research and get back to you.
Thank you so much, everybody. Thank you so much for your valuable inputs. And on behalf of our Center for Environmental Law and Climate Change, I'd like to thank you, Professor Alexander, and all the joinees. You made this entire session very interactive and interesting. And with that, thank you so much. And lastly, because it's Earth Day, I'd like to say that there's a spectrum of actions that we can take in our day-to-day activities that can add up to make a real difference. And acting now and together to live more sustainably is necessary to avoid the worst effects of climate change. And I'd like to leave you with that. Thank you, everybody. Have a wonderful weekend ahead.
Thank you.
Thank you, Alex, and thank you, Stuti. Thank you very much.
Thank you so much. Thank you all.